Please, Your
Yes.
Lordship. I beg to mention item number 16, Lordship.
16.
Yes.
Yes.
Here, Lordship, the petitioner instructed me to withdraw the case. This
Oh.
is a promotion matter, and he going to retire this month.
Okay. Mr.
M. Bhatt, Lord.
M. Butler and counsel for the petition has submitted on instruction that the petition does not want to pursue the writ petition. First of, in view of the above submission made by Mr. Butler and counsel for the petitioner, the writ petition is dismissed on withdrawal.
Yes, most of it.
Made to the Lordship.
Yes.
My Lord, I beg to mention item number 29.
25.
29, my Lord, and papers of accommodation, my Lord.
Yes.
Can it be taken up after a week, my Lord? I've informed the other side.
Okay. You have informed the other side.
Yes, my Lord.
Mr. D. Panging, and counsel for the petitioner, has made a prayer for adjournment of the case for a week. It is submitted that consent has been taken from the learned counsel for the respondents to make the prayer. In view of the same, the prayer is allowed. We'll raise the case after we connect it will be fixed by the office.
May it please, Lord. My Lord, I beg to mention item number 32 or 22, my Lord. My Lord, adjourned for the 1 week, 2 week, my Lord.
It has come up for order.
Yes,
Let
my
us
lord.
see.
Affidavit is not ready, my Lord.
22.
22, my Lord. The termination of the service from the
Affidavit filed.
not yet, my Lord. I know, swearing
yet.
court affidavit.
By 234, it has been filed. Anybody
2, 3, 4
knows?
we filed.
Who are 6 and 7? Respondent number 6 and 7. You have not taken steps. Office note says,
6 and 7, my
you
Lord.
take the steps.
Okay, my Lord.
Heard Mr. Sorensu and counsel for the petitioner. Close the. In view of office note dated 23, no, office note dated 23/04/2026 has reported that steps for service of notice upon the respondent number 6 and 7 have not yet been taken. Close the. Mr. Sorensu has sought for 3 days time to take steps upon the respondent number 6 and 7 in reference to order dated 4/7/2025. The prayer is allowed. This is the case after
Much obliged.
4 weeks.
May I please, my Lord? My Lord, I beg to mention item number 18.
18.
Yes, my Lord. My Lord, due to the urgent work, leading counsel Mr. K. Tasso for the sole respondent is out of station, my Lord.
Hmm.
So matter may be adjourned for today and
What is the matter? Contempt case.
yes, my Lord.
Affidavit file. Is which for the respondent?
Yes, I am for the sole respondent.
You have said you have complied with. You have
Pardon, my
complied with the order. Who is the petitioner? Who is
Yes,
for the petitioner?
Lordship, I'm for the petition.
Order has been complied with. Is it not?
Not.
Who will examine? Affidavit is filed
Yes.
Yes, Lord.
and it says that order is complied with. You wait for your turn. Look at the affidavit. No point keeping it pending.
Lordship, I would like to mention item number 14, Your Lordship.
14.
I'm mentioning on behalf of Estapin. He is the standing counsel of APSSB, Your Lordship. Lordship, may I kindly take up this matter after 2 weeks,
2022 review
Lordship.
on the prayer of Ms. So-and-so, Learned Counsel on behalf of Mr. S. Tapin,
Lordship.
Standing Counsel,
Yes, Lordship.
APSSB.
APSSB. Yes.
Release the case after 2 weeks.
Lordship, another matter, item 28, Your Lordship.
Yes.
Lordship may kindly take up this matter on 6th of May, Your Lordship. I have taken the consent of the petitioner, Your Lordship.
Ms.
6th May.
So learned government advocate has made a prayer for listing of the case on 6/5/2026. It is submitted that consent has been taken to make such prayer from the learned counsel for the petitioner.
Lordship.
Mr. Pangi, learned counsel for the petitioner, who is present, has submitted that he has no objection to the prayer if the case is listed on 6/5/2026. List the case accordingly on 6/5/2026.
My Lordship, I beg to mention item number 5. On behalf of T. Tapak, leading counsel is out of session. We have taken consent from other party.
You are for the petitioner?
Yes, Lordship.
Okay.
Lordship,
Mr. So and so. Learned counsel on behalf of Mr.
B. Sivo on behalf of T. Tapak.
T. Tapak.
Yes, Lordship.
Okay, learned counsel for the petitioners. List the case after 2 weeks on a date to be fixed by the office. It is submitted that consent has been taken, huh? From the learned counsel for the respondents to make the prayer.
My Lordship. Lordship, I beg to mention item number 6, 7, and 8.
7 and 8.
6, 7, and 8.
Or 6, 7 and 8.
I'm-
Yes.
I'm appearing on behalf of Pada, Ojing Pada, for respondent number 7. He's out of
Okay.
station.
You are for the petitioner?
I'm for the petitioners.
Okay, Mr. When do you want?
After maybe come after 3 weeks.
Mr. Swenson, learned counsel for the petitioners is present. On the prayer, Mr. Swenson, on behalf of Mr. O. Pada, learned counsel for the private respondent.
Yes, Lordship.
Okay. Release the case after 3 weeks on a date to be fixed by the office, as the prayer is not opposed by the learned counsel for the petition and the other respondents.
There is an interim order, madam.
The interim orders passed earlier shall continue till the next.
Obliged.
Lordship, another item also, item number 26.
26.
Yes, Lordship.
Yes. On behalf of Pada,
Yes, Lordship.
you have informed.
Yes, I informed the other side.
Okay. Mr. Swenson, learned counsel. On behalf of Mr. O. Pada, learned counsel for the private respondent, has made a prayer for adjournment. It is submitted that consent has been taken from the learned counsel for the petition and other respondents to make the prayer. List that is as sought for after 3 weeks.
3 weeks, Lordship.
On a date to be fixed by the office.
All right. May I, my lord? My lord, I beg to mention item number 9 of today's list.
9.
Yes, my lord. Leading counsel is unable to attend court today due to participate in bar sport meet, your lordship.
Participation in
Bar sport meet. Annual bar sport meet, football.
annual sports meet. Okay. For the petitioner.
Yes, my lord.
Okay, Mr.
K. Moses.
Learned counsel, paying for the petition, has made a prayer for adjournment.
I have taken consent from other side also, my lord.
The consent of the learned counsel for the respondents, as sought for and agreed to by the learned counsel for the parties, list the case after how much?
1 week, my lord.
1 week on a date to fixed by the office.
Okay. Deeply honored, my.
Yes, madam.
Lord, if I may mention item number 10 on
10.
behalf of Mr. Tititara,
Okay.
the conducting counsel,
Busy sports meet.
no, like personal difficulties
Okay.
with the
On prayer
consent of
please.
other parties.
Your name, please.
Elizabeth.
Elizabeth, learned counsel. On behalf of Mr. T.T. Tara, learned counsel for the petition, has made a prayer for adjournment with the consent of the learned counsel for the respondents. First of
After a week,
for and agreed to by a party, learned counsel for the parties, leaves the case after?
Huh?
After?
after a week.
After a week on a date to fixed by the office.
May I, Lordship? Lordship, I beg to mention item number 27, Lordship, on behalf of M. Kato. Due to some personal difficulties, he is
DY,
not here,
GY.
Lordship. Sorry,
Kato
Lordship.
is Deputy Solicitor General.
Yes, Lordship.
On behalf of the petitioner side, I strictly objected the prayer, Your Honor.
Why, Miss?
Because, Your Honor, in the last occasion also, due to some misunderstanding, they took the starting point of mention. I accepted that them. And second time also, after took the said date by the opposite party, this date be the fixed matter, Your Honor.
When Mr. Kato would be available?
Lordship, next week, Lordship.
Next week.
Yes,
Next week, then same date, Friday?
Your Honor, my objection may be recorded, Your Honor, because the petitioner, the party, client
Your
is,
name, please?
yes, Your Honor, M. Bagra, Your Lordship.
Miss,
Why, Gao, Lordship?
why?
Gao.
Gao Learned Council has made a prayer for adjournment on behalf of Mr. M. Kato, Learned Deputy Solicitor General of India, for the respondents,
Yes, Lordship.
Indian of India respondents. It is submitted that Mr. Kato is out of station due to personal reasons.
Yes, Lordship.
Close stop. Where Mr. M. Bagra, Learned Counsel appearing for the petitioner, has made an objection to the prayer for adjournment. Close stop. In view of the ground cited for adjournment, the prayer is allowed. Release the case on next Friday.
8 of May, 8 May, fixed matter here.
8 of.
Much
Yes,
obliged.
Lordship.
Item number 1.
You have any prayer?
Your Lordship, I'm extremely sorry, Your Lordship. I need to withdraw this petition.
Which one?
Item number 1, Your Lordship.
Oh,
Your Lordship, I have failed to annex one vital document, though I have mentioned in my petition and index. But
okay.
in
File it
index-
afresh. Mr.
IBAM, Your Lordship.
I.
Bam.
Bam, Learned Counsel for the petitioner, has submitted the due to inadvertence and an important extract could not be annexed to the petition. He has therefore wait for he has submitted that the petition may be allowed to withdraw the petition with the liberty to file afresh.
Yes,
Mr.
B. Siva, on behalf of Titapak, Standing Council of IOC.
B. Sibo, Learned Counsel, on behalf of Mr. T. Tapak, Learned Standing Council,
Oh,
Oil India Limited,
Yes, sir.
Oil India
yes, sir.
or IOC.
IOCL.
IOCL is present. In view of the above submission made by Mr. So-and-so, Learned Counsel for the petition, the petition is dismissed on withdrawal with the liberty as prayed for.
Much obliged.
Item number 2.
May I plead?
Yes, Mr. Mo.
Yes, my lord.
I am feeling intimidated. Yes.
Yes, my lord.
How
But
many
this-
petitioners?
My lord, 93 petitions, my lord.
93. What
Yes,
is
sir.
this common cause of action?
Common cause of action is that their land has been transferred to the forest department, especially for the camper fund, without their consent, without their knowledge. Some of the respondents, we have made it in our writ petition. They have executed the agreements, total around 11 agreements with the forest department, and they have used the money showing the land of the petitioners in different villages. So I just can take
You want to say fraud?
Yeah, obviously it's
Fraud.
fraud, and money has been misutilized without even implementing the fund, my lord. They have shown in the geotech that we are doing activities of plantations, and then we are doing maintenance as per the activities reports and fund
Let us read
utilization.
your synopsis instead of going
Yes.
through the petition. Lower Dibang Valley District.
Yes, Lord District, Lord District.
How land ownership is established in Arunachal Pradesh?
Arunachal Pradesh, my lord, we have the villages and we have village boundaries, and then
Village boundaries are defined.
defined, and then individuals, they know the boundary of of individual family. They know where is
Any
their,
documentary evidence?
in some cases, they have a land possession certificate, but usually in the villages, they don't apply for even for land possession certificates. So they
Suppose
only-
you claim that my boundary is up to this limit,
Yes,
and he claims that no, my boundary is beyond the limit.
yeah. In that,
If two are neighbors, how the matter is resolved?
in that case, Malat, we have Gamburas, head of the Gamburas,
Oh.
and the elders of the villages. They will decide that
That is
That-
Kebang or what?
among, yes, under the civil procedure code for Madhya Pradesh, Malat.
But who maintains the land records?
There is no such
No.
no such land records are maintained, Malat.
So how you claim your legal right?
Malat,
Just by possession.
just a position, Malat. We are doing June cultivations, we are doing agriculture, and we also,
So if the matter comes to the court, civil
Yes,
court, how do you establish it? How do you,
Yes, Malat.
how do you lead evidence
many cases,
to
Malat,
establish your position or wrong position, wrong occupation?
then Malat, Kabang decision will be there if there is a
Okay.
decision, Malat.
But nobody maintains record,
Nobody maintains records, Malat.
only eye estimation.
However, individual have, if there is a dispute, if there is some decision of the village level, or there is certificate issued by the Gambura saying that this boundary belongs to you.
Gambura is powerful.
Gambura is powerful now. He is powerful under the Arunachal Pradesh Civil Court, Malat.
Okay. So, So you want to say that DFO and some private individuals entered into agreements?
Yes. And then they have utilized,
That persons are made private respondents.
we have made a private response.
And DFO is named by, is named,
Yes,
is
by,
implemented as a party
yes, we have made
by
a,
name.
by name, Malat.
But officially he should have also have been implemented.
Official also we have implemented who are the in charge
Officially are not implemented.
of
Ibu Tana. But you have not implemented his office. Check.
it says page 22, Malat. As an official, he is the implemented, Malat.
No, that is individual implement. That is individual implement,
Yes, Malat.
not official implement.
Malat,
Response number 7.
response, Malat.
That is by name, individual. He
Yes,
will be answering your case individually, not officially.
Yes, Malat. Because main parties, Malat, that can be,
No, it is up to your eyes. I just,
I got it, yes.
it got to my notice, so I have
Yes, yes, Malat.
indicated to you.
Yes, Malat.
There's a very complicity of-
If necessary.
Happy may be feeling.
Individual.
So far, your prayer regarding declaring the agreements illegal, I think that is not within the purview of the 226.
We
This will be
are,
purview of the civil court.
we are praying that should be set aside, my lord.
That can, we don't set aside 226, we don't set aside agreements. First, it has to be established as a void and illegal,
Yes, my lord.
contrary to the provisions of the Contract Act. That a civil court can set aside and declare a contract null and void. 226, show me any example, any authority, right from any high court or any Supreme Court that by mandamus or certiorari, a private contract. This is not statutory contract.
But this is between the state
No,
also
that
involved.
does not make. There is difference. It is not under Article 298 of the Constitution, this kind of agreement. It is not a statutory contract, nor a contract under 298. Even if it is 298, it is still a private contract. And it is governed by the provisions of Contract Act. And show me any authority that court exercising power under 226 has declared any agreement null and void or illegal or set aside. Any authority. And you have asked for this CAMPA, okay? But first prayer, I don't think.
Other prayer, my lord.
And third prayer also. This is also within the scope and ambit of civil court. Restore possession. It is declaration of right, title, and interest. Is it not? And have you filed any FIR?
Yes, we have filed complaint, my lord. FIR also filed, my lord. FIR also been filed, my lord.
FIR file, investigation done.
Not.
Have you said so? Where is that statement? Which paragraph?
My lord, just, my lord,
I have
FIR,
serious doubt about maintainability of some of the prayers.
but then, my lord,
The restoration of possession is not the purpose for which Article 226 can be invoked. Right.
we will not stretch which if it can be invoked.
And secondly, to declare these agreements legal or illegal, that is totally within the purview of the civil court. And restoration of possession, restoration of title, all these are within the purview of the civil court.
My lord, my lord, your lordship may see that. But the rest of the prayer, I think that is.
That no, just that I have seen.
Some
now,
prayers, my lord.
Everything has to be seen now.
Yes, my lord.
All this CAMPA fund, recovery of CAMPA fund, first you have to establish by leading evidence that the agreements were illegal, right?
But we will.
Then restoration of possession.
Yes, my lord.
Then this CAMPA fund misutilization.
So we will be stressing on the some other prayers, my lord.
Yes, Mr.
My lord, I'll be appearing for Respondents 3 to 6.
What do you say about?
Yes, my lord, some of the, in fact, the basic all rest prayers.
I could understand you have filed an FIR after registration of the case, investigation is not done properly, right? Then you can say that you,
No, we have.
this is a huge scam,
Yes.
huge scam,
Yes, sir.
and some monitored investigation or SIT or by CID or by CBI. Yes, court can examine. But restoration of possession, all these declaration of agreements illegal and void, all these are not within the purview of this court, right? And first you have to establish these agreements were illegal by leading evidence.
But,
By leading evidence,
but,
they will come. We have entered into it.
my lord, in fact, regarding the agreement, my lord, I can
I
just.
will issue notice, but I express my
Well,
observation also, reservation
well,
also.
In fact, all this, apart from the prayer for setting aside the agreements and also the restoration of
Yes.
possession and the other prayers also,
Mm.
that can also be granted only if there.
That agreements are declared illegal.
My lord,
And the petitioners have the right, title and interest over the land.
Yes.
That has to be established by leading evidence. That
No,
is
my-
the purpose for which I asked the
Yes, my lord.
questions first.
my lord, I can just show you some documents, the corresponding of the authority, my lord. All the agreements, my lord, they have considered it's illegal, and accordingly, they have cancelled all the agreements, my lord. I can show that documents, my lord.
Then the first prayer is not redundant. If it is declared as illegal, by,
But-
who, by whom?
By the authority.
By the authority who has no authority, I mean, the divisional forest officers, but it's not clear whether he has authority to declare. That is there.
That is, the declaration is to be from the civil court. That you have to lead evidence that first, I have the right, title and interest over this land by virtue of my long position and as recognized by the Gangura and all.
No,
Right. And second, despite my long occupation and without my consent, an agreement which is entered into, which is completely in violation of the Contract Act. Because that contract is not statutory contract.
Contract.
Right. And the person, DFO, has no authority and jurisdiction to enter into such contract. And these are persona non grata who cannot enter into any agreement in respect of my land.
Right.
These declarations are to be from the civil court. Then you can get your position back. As a consequence, all other things will be established. If you establish, then Campa Fund is misappropriated.
No,
Clear case.
no, my lord, I can just show
We can issue notice, but I have my reservation.
Keeping the question of maintainability.
But I will satisfy, my lord.
I have some reservation, we'll issue notice.
Keeping the question of maintainability open. my lord.
Yes. And some of the prayers
Yes, my lord.
are tentative view, some of the prayers
we
not
are-
be within the ambit and scope of 226, but within the ambit of a civil court.
No, like, that's no issue, my lord.
This observation, tentative in nature, I would observe.
Yes, my lord.
No issue, my lord.
Then we'll proceed.
But the rest prayer.
The rest I am not examining.
Right.
But Mr.
Esmo.
Esmo, learned counsel for the petitioners. Who is for 1 and 2? Miss so and so for. Okay, Mr. DS. DY for the responder 1 and 2.
I'll be for 3 to 6.
3 to 6. Mr. I got confused.
Enratan.
Hmm?
Enratan.
Right. Sorry. 3 to 6. Additional Advocate General. Poster. I also record your objection.
Yes, ma'am.
Okay. Issue notice returnable in 4 weeks. As Ms. So-and-so, on behalf of Mr. So-and-so, for 1 and 2, Ms. Roton for 3 and 6, have appeared and accepted notice.
3 to 6.
3 to 6. Issuance of formal notice to the said respondents is dispensed with. However, the Land Council for petitioners shall furnish requisite number of extra copies of the writ petition along with an annexure to Ms. So-and-so and to Mr. Norotan within 3 working days from today. Poster. The petitioners claiming to be landowners see the synopsis, landowners having lands in villages, in a number of villages, including named the villages, Ilopa, Chibu, Kevali. So it is a case of the petitioners that between December 2020 and June 2023, 11 number of agreements were illegally executed among the private, among the respondent number 7 to 20. 7 to 20. In respect of parcels of land, which actually belong to the petition, which ownership of which are claimed by the petitioner. So it is a further case of the petitioners, that on the basis of those illegally executed agreements,
And fund also been utilized against that land.
on the basis of those illegally executed agreements, the respondents had illegally disbursed amounts, a huge amount from Campa Fund. And misappropriated the same. Full stop. Mr. Roton, Land Additional Advocate General, EP, has raised the issue of maintainability of the writ petition. Full stop. Which he has submitted that with some of the prayers are not to be examined. Some of the relief sought for by the petitioners in this petition are not to be examined within the scope and ambit of Article 226 of the Constitution of India, as they are to be established by the petitioners by leading evidence before a civil court. So we has further submitted that depending on the findings in a full-fledged trial, the other relief sought for in the writ petition can be considered. So, having regard to the prayers made in this writ petition, The court is of the tentative view that some of the prayers relief sought for in the petition are not within the scope and ambit of the power of judicial review available under Article 226 of the Constitution of India. So, be it as it may, the issue of maintainability will be considered at an appropriate stage. Before that, steps of the learned counsel for the petitioner. The petitioner shall take steps for service of notice upon the respondent number 7 to 20 by speed post with ready within few working days from today.
My lord, we will be also allowed to serve through Dusty also.
Dusty.
Yes.
Okay.
That's
As sought for by the petitioner to the petitioners are allowed to serve notices upon the respondent number 7 to 20 by way of Dusty, which is to be routed through the registry. Post up after effecting service of notice upon the respondent number 7 to 20, the petitioner shall file a compliance affidavit to that effect within 4 weeks from today.
obliged.
What are those marketing annexers? Agreements?
Agreements, my lord, and we have enclosed some
How you have got the agreements?
to RTA, my lord.
Okay.
Obliged.
Item number 3.
Ahmed, please, Your Lordship.
Yes.
Lordship, I have, Your Honor, my Lord, agreed by impugn order dated 5/1/2024.
5/1/2024. Who is that?
Yes,
Where is that?
That is, Your Honor, whereby 50% of my pension and gratuity.
Page.
Of page number, annexure, page number 49.
49.
Yes, annexure 12.
A case was registered against SCOD SP, special writ. You retired as superintendent of police?
Yes,
Okay.
yes, my Lord. My Lord,
Ita case number so under section 342 registered as ZR case number so was registered court of session case number so for trial and disposal convicted. Therefore, guilty. There was a conviction.
yes, my
Thereafter, any appeal preferred?
Yes, my Lord. Appeal was prepared, my Lord,
Preferred
and
dismissed
Your
or
Honor, yes,
allowed?
allow, Your Honor. It was sentence was reduced, Your Honor.
Sentence
Yes,
reduced.
reduced.
Then you undergo imprisonment?
Yes, I was undergo imprisonment and I was
Or-
released on
When?
remission
Okay.
in the year 2012. And I was actually fact of the case is
You retired when?
retired in 2008. After my
Retired in 2008.
yes, after my retirement, this conviction
Conviction.
was yes conviction, and after my Lord.
What
on-
is this a rule 81 CCS pension rules?
My Lord, before that, my Lord, on 1st May 2024, respondent.
But why you have come so late?
No, my Lord, 1st May 2024, my Lord, respondent number 2 passed 2 orders. Respondent number 2 passed 2 orders.
On which date?
On 1st May 2024. This impugn order as well as, my Lord, another order. It is
This
in
is
page number.
withholding of 50% amount and
Yes,
gratuity.
and page number 48, annexure 11.
Annexure 11.
Yes, page number 48.
SC Odhikari.
Yes.
That is.
Yes, my Lord, it is in my suspension was revoked on. Yes, and last break.
Okay. 1 minute. Let me read.
Okay, okay,
Madam.
okay.
Spent on duty for all purposes.
Yes, my Lord.
Okay.
And after that, my Lord, this impugn order was passed, and consequential order was also passed.
this impugn order has been passed,
Yes,
whereby 50% has been withheld.
yes, my lord, and respective effect from 27 June 2022.
50% of the pension and gratuity
Yes, my lord.
from 27 June 2022.
Yes, my lord.
So it is about 2 years.
And
Then
yes, my lord.
anything?
Yes, my lord. Before that, your my lord, in page number annexure 9, page number 45.
Page
my lord.
number 45.
Yes. Yes.
You are taking me to some earlier thing. Yes.
Yes. On 27 June 2022.
Right
Yes,
to
my lord.
convey the government approval granting sanction on the following points. Treating the period of suspension of duty, the issues okay, this has happened.
Yes, my lord.
Now, just a minute, where is your prayer?
My prayer is
Prayer is what?
my prayer is, Your Honor, I may be, Your Honor.
1-5 impugned.
Yes.
Should not be issued 28/1/2026. What is that?
21, this is order for recovery of
What is
already.
that?
Yes.
Page.
Page number 64.
Why this has been made?
For recovery of my provisional pension.
Excess amount of provision pension paid for Yes, madam. What is your interim prayer?
My interim prayer is, Your Honor, stay of these two impugn orders.
1-5 I cannot stay.
Yes.
1-5 you have come after 2 years. 28/1.
Lordship, this petitioner is a retired employee who has been convicted after retirement, Your Lordship.
After retirement.
So in this, such cases, Your Lordship, granting of pension comes under the provision of Rule 8 of CCS pension rule, Your
Let us
Lordship.
see Rule 8. CCS.
CCS pension rule, Lordship. Page 532.
When did he retire?
Retired in 2008, Your Lordship.
2008.
Yes.
Then
And
entire
convicted-
suspension period you have
Yes.
treated as spent on duty.
Yes, Your Lordship.
Then he was made to retire. He retired on
2008.
After retirement, he has
which
been.
date? Which date?
31st May 2000,
31st May 2008.
2008. Yes.
Then when he was convicted?
Convicted
He was
in the year 2009, Your Lordship.
9. Rule
Rule 8, Your Lordship.
8. Okay.
Pension subject to future good conduct, Your Lordship. Sub-rule 1A.
Shall be an implied condition.
Sub-rule 1A and B, Your Lordship.
Where is the notice?
Yes, Your Honor. Notice.
Under rule,
Yes.
sub-rule 3.
Sub-rule, whether, Your Lordship, notice has been issued, Your Lordship,
Your
at this
Honor.
stage,
No notice was issued to me, Your Honor. Even I have filed representation for opportunity of heard, Your Honor. But it was not allowed, Your Honor. Not. taken
Notice,
at
is
that-
there any notice? There has to be notice because
No, there was no notice, my lord.
it affects the rights of the petitioner.
Yes.
Any notice? Order is a case registered, first court. The conviction was after your retirement
Yes, my lord.
Yes,
and appeal partially allowed
partially.
on sentence.
Yes, my lord.
Conviction remained,
It remains. Yes.
but sentence was
Yes,
reduced.
yes.
Okay. That was, pension order was in 2024, 50%.
Yes, my lord.
Prior to that, I think during the said period, up to 1st May, you continue to get provisional pension.
Yes,
Yes,
madam.
provisional. Yes, yes. And regarding his conviction, Your Lordship, that has come to the knowledge of the authority only on 5/8/2019 at page 35, Your Lordship. This letter has been written by the Director Audit and Pension to the DGP, Your Lordship. Page 35. And after that, Your Lordship, in 2022, Your Lordship, government has approved for granting pension, Your Lordship, at page 45.
He made a request for review. That is a different matter. But where is the notice? For a copy of withholding regarding recovery. It must be recovered. Come to page 64. Now, Director of Audit directed Accountant General to make recovery from his future pension, right? As regards excess amount paid during payment of provisional pension,
Yes.
right? That is on 28th January. This is not directly addressed to you or to address to, it has been addressed to you. Copy.
Yes, a copy, sir.
Huh. Final decision is not taken.
Not taken yet. This is only the communication, Your Lordship.
Communication, Director of Pension is writing
Yes.
to the Accountant General that excess provisional pension which has been paid to the retired may be recovered.
Yes.
May be recovered or adjusted from his future pension on installment basis of 1/3 of net pension plus relief payable each month unless the petitioner's concern gives his consent in writing.
Yes, ma'am.
Pay a higher interest.
Right. So then this sub-rule 3 will come in.
Yes.
Serve upon the petitioner a notice specifying the action proposed to be taken against him and the ground on which it is proposed to be taken and calling upon him to submit within 15 days of the receipt of the notice or such further time not exceeding 15 days as may be allowed by the appointment authority. Such representation as he may wish to make against the proposal and take into consideration the representation, if any, submitted by the petitioner under clause A. So, let us read 1, 2 also. Rule 8(1)(a). Future good conduct shall be an implied condition of every continuance under these rules. Continuance, right? Appointed may by order in writing withhold or withdraw a pension or a part thereof. Right? That order has been made on
Yeah.
1st May.
50%.
50%. Whether permanently or for a specified period, it is permanent.
From
If the pensioner is convicted of a serious crime and is found guilty of grave misconduct. That has been done.
Yes.
Provided that where a part of the pension is withheld or withdrawn, the amount of such pension shall not be reduced below so and so. 2, where a pensioner is convicted of a serious crime by a court of law, action under sub-rule 1 shall be taken in the light of the judgment of the court relating to such conviction. That is a trial court if something is observed. In a case not falling under sub-rule 2,
Not falling.
not falling, if there is no direction
Yes,
of the court of law, if the authority referred to in sub-rule 1 considers the petitioner primarily guilty of a grave misconduct itself before passing an order under sub-rule 1, serve, that is its continuance
Yes, it's continuous.
or grant
Granting
of
pension.
pension. What is this office memorandum 16/5/2018? Come to page 64. But come to clause 3 of the impugned letter. In view of the above, it is therefore requested that a suitable instruction may please be communicated to the concerned treasury on the issue for necessary action based on the order.
Yes.
So it is final. But where is the provision for recovery without some notice is required?
Lordship,
Hard.
there was a
We
notice.
were already withhold 50%, 50%. We'll examine this issue.
Lordship, notice may
We'll
be.
examine, notice will issue and this,
We'll file our affidavit.
there shall not be any further recovery. As indicated in our heart, Miss, you are legal aid counsel?
Yes, in this case, legal aid counsel.
Okay, J. Doji.
Yes, my lord.
Learned legal aid counsel for the petition. And Miss
Arbasar.
R. Basar. You are state counsel
Yes, Your Lordship.
for all?
For 1 to 6, Your Lordship.
1 to 6. Any standing counsel for accountant general?
No, Lordship.
No.
I'm not aware of.
Notice has to go.
Yes, Lordship.
Any standing counsel, madam?
West Bengal.
Accountant general? No.
No, here.
Okay. The petitioner retired from service as superintendent of police on reaching the age of superannuation on
On 31st May 2008.
31st May 2008. Full stop. prior to his retirement, a case, Itanagar Police Station case number 76/2007 under section 342, 376 IPC was registered on 29/03/2007. Postal. In view of the registration of Itanagar Police Station case number 76/2007, the petitioner was placed under suspension by an order dated 12/4/2007, WEF 29/03/2007. Full stop. By an order dated, in the trial of Sessions case number 513/2008 within bracket FTC-UYPA bracket close. Before the Court of Learned Additional Session Judge within bracket WZ, First Track Court, UPA, arising out of Itanagar Police Station case number 76/2007, after conclusion of the trial, the petitioner was convicted for the offense under section 376,
Yes.
IPC by judgment and order dated 30/11/2009. Post by an order dated 1/5/2024, the period of suspension of the petitioner was revoked by an order. By an order dated 29/1/2008, the period of suspension, the suspension of the petitioner was revoked. Post up. On an order dated 1/5/2024 was passed, whereby the period of suspension of the petitioner was treated as a period spent on duty for all purposes. Post up. By another order dated 1/5/2024, issued in passed in exercise of the powers conferred under Rule 8 within bracket 1 of the Central Civil Services within bracket pension bracket close rules, 2021 as amended. The 50% of the pension and gratuity has been withheld permanently. WEF 27/6/2022. Full stop. The said situation continued thereafter till 28/1/2026. Full stop. by the impugned order dated 28/1/2026, the respondent authorities have sought to recover an allegedly an amount of rupees 15,25,568 from the petitioner on the ground that the said amount has been paid to the petitioner in excess while dispersing provisional pension. First off, an instruction has been placed to recover stroke adjust the said amount from the petitioner's pension on installment basis at 1/3 of net within bracket pension plus relief bracket plus payable each month. First off, agreed by the aforesaid decision of the respondent authorities to recover the amount allegedly paid in excess. The petitioner is before its court by the instant commission. Otherwise, recovery at a distant place is not very welcome step. Issue notice returnable on Swenson. As Ms. Swenson has appeared and accepted notice on behalf of the respondent number 126. From notice dispense with legal extra copy you need to work in this steps upon the respondent number 7 by speed post within 3 working days. Having regard to the above facts, the petitioner has retired from service on reaching the age of superannuation as far back as on 31/5/2008. First off, after release of provisional pension after his retirement, his pension was finalized on 1/5/2024. 1/5/2024.
Yes.
And in terms of Rule 8 within bracket 1 of the CCS within bracket pension rules. First off, the subsequent by the impugned order dated 28/1/2026, an amount of rupees 15,25,568 has been sought to be recovered from the petitioner on the ground of excess payment at the time of disbursement of provisional pensions. So, having regard to the above facts, it is ordered, in the interim, that there shall not be any recovery from the pension of the petitioner in terms of the impugned order dated 28/1/2026 till the returnable date.
Obliged.
Item number 4.
Go Taja. Yes. Right, so the case is in possession of Pratap land located in Gumina, Fazilhat. 90,000 square meter.
9,000.
90,000.
It's 9,000.
You said in synopsis 90,000. You own a village.
It is the typing mistake. It is 9,000.
Typing mistake.
Yes, 9,000.
Okay. It is private land. Standing fence of bark were erected by plaintiff, making his possession and ownership. Where is that 17/4/2026 order?
That is in the page number 39.
What is this pen drive, sir?
Your Worship?
Pen drive, pen drive? You have annexed a pen drive also?
Yes, yes. This is just video.
Video?
Yes. They are
Where is
dodging,
that
they are dodging my land with
17/4/2026 order?
page 34.
Yes,
39, Your Worship. 39, 39.
39.
Annexure 6.
Oh, there is no type copy?
The,
Well,
no, it is very clear.
It has been
Sorry.
reported that some they were enforcing. Now, page 40,
Yes, Your Worship.
see your representation,
Yes, Your Worship.
second paragraph.
Yes.
In the area adjacent to the land of the Veterinary Training Institute, I have my own private land plot, which is clearly distinct from the land of the IDDP and Veterinary Institute. My land does not fall within their land. It is a totally separate land. I am a rightful landowner, as my grandfather has neither compensated nor any activation has done. I have also submitted representation to your office seeking LPC against my land.
Yes, Your Worship.
So if your land is separate,
Yes.
it does not touch this thing,
Yes, Your Worship.
this IDDP,
Yes, Your Worship.
right?
Yes.
This 17 April order.
Yes, Your Worship.
How can we say that you are aggrieved?
That is the issue, Your Worship.
Huh?
Because
Because you say this thing, then you say second in the next paragraph, a case title suit number so and so is pending, sub judice, and you are a party, deputy commissioner. But so therefore, 152 order under section
yes, yes.
should not be passed.
Yes, Your Worship.
But here in the first paragraph say that my land is this thing.
Yes.
So
So-
this order has been passed only in respect of, I think, IDDP and Veterinary Institute.
Yes, Your Worship.
Hmm?
So that is the issue, Your Worship. Now,
How you are aggrieved?
their total area is 42,000 square meter. All total, the area of the veterinary science and the IDDBP is 42,000 square meter. So that is not in dispute as per my contention, Your Worship. Now, contention that being raised by me is that in the guise of that 42,000 square meter, they are claiming my land, that my land falls under it.
Get a restraint order in the title suit.
Yes, but now, as of now, it is not possible, Your Lordship, because the notice is yet to be, they are yet to appear before the court.
Huh?
As of now, it is not possible to.
No, an interim injunction order is available.
No, because Your Lordship,
Since they are not passing the order, you come before this court. That is not the word.
No, no,
You press the add interim injunction order in
Your
the
Lordship,
title suit that don't encroach my land.
may I please take Your Lordship to that order of the civil judge, Your Lordship?
If you are
Page 17, Your Lordship.
page
17.
page
Page 17, Your Lordship.
17.
Yeah, 17. This is the first order of the before the civil court. So what I'm submitting, Your Lordship, is that as of now I'm not in the position to obtain injunction order because they are yet to appear before the court, and
No, you can
because notice under
specific relief act.
yes. So it clearly says that no injunction shall be granted before the party appears before the court.
Where?
That the specific relief act. It says that the injunction cannot be granted before the parties
Specific
because, Your Lordship, no notice was issued to them. Section 80 was exempted.
specific relief. What kind of specific relief act? I'm surprised. Yes, Mr. Ratan, I don't know if anything defined in Arunachal Pradesh.
No, my lord, I'm also surprised how specific relief act when there is no instrument for performance of any.
I'm very sorry, Your Lordship. I haven't brought the book today, Your Lordship, but I.
No, it's okay.
Instrument for which
Defense respecting suits for relief based on contract.
yes, ma'am.
Section 9.
Yep,
Right. Then 34. Declaratory decrees. Discretion of court as to declaration of status or right.
One has to have an obligation, counter obligation.
Something wrong somewhere.
Your Lordship, all I'm praying today is that the order of status quo may be passed. That's all I'm praying today.
When something is not impinging upon any legal right, why will pass status quo? Because order says veterinary land is encroached by somebody.
Yes, my lord.
Now,
if your land is distinct
yes, Your Lordship,
and separate, and this order is only made in respect of Veterinary Institute and IDDP, then why and where this is available to you in the title suit to seek an injunction order?
Your Lordship, if you look at the page 38, then the things will be clear.
This specific relief act.
Page 38 of my petition, Your Lordship. Page 38 of my petition. Here, it clearly shows that they have encroached into my land. Page 38 of my petition.
That is what suit you have filed?
No, it is one annexer, which is issued by the.
You have already filed a position of the suit land.
Yes. Now, Your Lordship, may I kindly read this page 38, Your Lordship?
1 minute. Where you are prevented from seeking an injunction order? By which provision?
There is one provision that, which says that unless the party appears, no injunction can be.
Where?
I don't have the. I'm very sorry, but it is there, Your Lordship.
In the specific relief?
Yes. Yes.
Temporary injunction. Temporary injunctions are granted, are such as are to continue until a specific time or until the further order of the court, and they may be granted at any stage of a suit and are regulated by Code of Civil Procedure. And Civil Procedure Order 39, Rule 1 and 2 permits you to seek exemption. And it also permits you to seek injunction ex parte.
No.
I am not come across because injunction is CPC. Don't multiply the proceeding. When relief is available before you, before the civil court, remedy, don't multiply and jumble up everything.
Nevertheless, Your Lordship, this order is
No, nevertheless.
even if
You have already instituted a suit
yes,
in February.
yes.
It is not that injunction application is to be filed then and there. You can file now also. Code of Civil Procedure. Right. And it is expert. I have not come across that court cannot grant. It is like ex parte stay order in writ petition.
In that case, Your Lordship, kindly pass over the matter for some time. I'll go through the and
You please go through.
yes.
No point.
Because there is Your Lordship. What there was one provision.
See, cases in which temporary injunction may be granted. There are many. Say, where in any suit it is proved by affidavit or otherwise. Any property in dispute in a suit is in danger of being wasted, damaged, or alienated by any party. B, that the defendant threatens or intends to remove or dispose of his property with a view to so and so. C, that the defendant threatens to dispossess the plaintiff or otherwise. Right. Court may, by order, grant a temporary injunction to restrain such act and make such other orders for the purpose of staying and preventing disposition of the plaintiff or otherwise causing injury to the plaintiff in relation to any property in dispute in the suit, as the court thinks fit, until disposal of the suit. Right. There is no bar in granting injunction ex parte. I have not come across it. It is first you have said. And Specific Relief Act says it will be governed by CPC. And CPC says Order 39. And Order 39 does not debar.
You should kindly grant me 5 minutes. Kindly grant me 5 minutes because I want.
Then Rule Order 39, Rule 3. Proviso. Provided that where it is proposed to grant an injunction without giving notice to of the application to the opposite party,
Yes.
the court shall record the reasons for its opinions.
Yes, may I go?
CPC Order 39. Okay, you come. You read in the meantime. I am offering you the book. If you read both the book, come here after some time.
Yes, sir. Thank you, sir.
Right.
Yes, sir.
Item number 11.
Nobody, madam?
Nobody.
Okay. There is no representation on behalf of the petitioner to be on call. Suspension.
Suspension.
Prolonged suspension.
Prolonged, but we have reviewed it, Lordship, time to time.
Reviewed it.
Yes.
By passing region order.
Yes, Lordship, we have passed reason order.
Okay. Ms. So-and-so land. Junior government, you're junior or senior?
Junior, Lordship.
Junior government for the state trust correspondence. is present in view of non-representation behalf the petitioner today on call, let the case be listed after 2 weeks on a date to be fixed by the office.
Item number 12.
Tadak Dupit. Yes,
Yes, Lord. I'm for the petitioner,
opposition not filed, counter not filed.
not filed, yes, sir.
Lordship, may kindly grant 3 weeks time.
Mr.
Your Honor, already this matter was listed earlier on 2 occasions for the same cause, but still they are seeking time. It is,
Only twice.
Yes, well, first
but
in
this,
Only
this,
twice.
this will be the third time.
State has the license.
Last, last opportunity.
The various husband. Preserves during occupation of various persons and the portio. Husband of by seeking allotment of a plot of land. Stated to it to be under his occupation. The petition disposed of an order with a direction to the respondent authorities to consider the representation of the husband of the petition number 6. Located. So you want to say that the earlier allotted plot have been declared unsuitable for airfield. So you
Yes,
need the allotment.
No,
You be granted the allotment.
no, actually, the land which we possess, it is not attached with the airfield there.
But there was an earlier round. All of you have filed a petition.
Yes,
WBC, right?
yes.
WBC number 91, 2021. That petition was dismissed, saying that there is no merit.
So, Your Honor,
Anyway, you file your counter video. How much?
3 weeks time, Your Lordship.
Court has made an observation that your case is primarily hit by doctrine of res judicata.
no, Your Honor,
And Mr. So-and-so Leonard Consport of petition and Ms. So-and-so Leonard renew my advocate for
All, Your Lordship.
all the respondents. Ms. So-and-so has sought for and is granted 4 weeks time to obtain the necessary instruction to file the counter affidavit on behalf of the respondents. List the
Okay.
case after 4 weeks on the 2 weeks by the office.
obliged.
Item number 13.
May it please your lordship.
No affidavit.
Uh, is that
So,
counsel is
what is your response?
We have not received our instructions yet.
So, what is your next submission?
We need some more time.
Same.
Your Lordship, I'm appearing on behalf of the SGA and Kato for respondent number 5.
Are you required to file any
No,
counter?
Your Lordship, no.
No.
No, Your Lordship.
I'll record.
Okay, Your Lordship. We are pro forma respondent here.
Okay. How much time?
3 weeks, Mama.
Okay.
my lord, any fixed date may be given.
Fixed date. Mr. So for a petition. You are Tunka?
Titunka.
T. Tunka. And Miss
Kiwangu.
K.
Wangmu.
Wangmu. Leonard Junior Government Advocate for the respondent number 1 to 4. You represent 1, 2?
1, 2, 3, and 6.
1, 2, 3, and 6. Who is for PWD?
We are for the PWD one.
Huh?
1, 2, 3, 6. And highway, there's
1, 2, 3. This four.
4, there's standing council, highway.
His name is shown or not?
Yeah, it's shown. Between 2 something.
Okay. And Miss,
O Jarang, Your Lordship.
on behalf of Mr.
M. Kato,
M. Kato, DY as DY for the respondent number
5, Your Lordship.
5. Full stop. Miss so-and-so has submitted that there is no necessity to file any counter affidavit on behalf of the respondent number 5.
Five.
Full stop. Miss Wang Mu has submitted that the necessary instructions to file the counter affidavit are yet not received. Full stop. And Ms. Wang Mu has thus sought for 4 weeks' time to obtain the necessary instructions and to file, or 3 weeks' time. 3 weeks' time to obtain the necessary instruction and to file the counter affidavit on behalf of the respondent number 1, 2, 3, and 6. The learned standing counsel PWD is
Highway.
found
Highway.
within bracket highway is found absent today on call. Release the case on the 3 weeks. Give it.
18.5.
Much obliged.
I'll come back.
Item number 15.
May I plead you also? In this matter, my lord, we have furnished the amended cost title, my lord.
As for number 8 and 9.
8 and 9.
Newly implemented.
Newly implemented, my lord.
Notice has to go.
Yes, notice has to go, my lord.
Okay. You have filed a memo.
Yes, my lord.
Eight and 9. Okay. Heard Mr. S. More learned counsel about a petitioner. Any state counsel? Okay. Issue notice to the newly implemented respondent number 8 and the respondent number 9. The notice is made returnable in 4 weeks. The petitioner shall take steps for service. Petitioners shall take steps for service of notice upon the respondent number by speed post. Within 2 working days for service of notice upon the respondent number 8 and the respondent number 9. This is the case of the 4 weeks.
Obliged.
Item number 17.
In this matter, original record was called for. Since the my tender paper was rejected in the technical bids, saying that I have used correction fluid. Now, as per TEC 16 subclause 3, page 41.
Page 41.
Right, Lord.
Yes.
Subclause 3. See, this is clause
Which
16.
should be legible, fill clearly any overwriting or cutting which is unavoidable shall be signed by the signatory. Use of correction fluid to it shall be liable for rejection. Yes.
Yes. On that
So
ground,
which bid?
on that ground,
Technical, financial, which one?
financial.
Financial.
Page 56, annexure 8 is the
Page
BOQ.
56. 56.
Annexure 8.
Your name, KK Enterprise. 56, yes.
Yes,
Which
this
page?
is my BOQ. Now,
BOQ.
yes. Now this is your lordship will find amounts its bigger amount in words. Now they say that this particular, it is handwritten. In this particular documents, I have used white fluid and I have
That can
overwritten.
be determined only by looking at the
Original documents, correct, Lucy. If my friend has the original documents, may Lordship may kindly peruse.
Actually, my lord, this case, my lord, it's related to 2024-25 financial year, my lord. Now, it has become infructuous, my lord. The work has been completed, my lord. Now, nothing remains, my lord. Nothing.
But he can seek damage.
Yes, my lord.
Correct, Lordship.
Yes.
So why, Lordship? As per my instruction goes, Lordship, my client has not used any white fluid in the documents. Of course, he has used a pencil. Why? Because that sometimes mistakes occur, and they use eraser to omit it, and they write it with pen. So that might have they might have seen it as using of white fluid.
Our affidavit says, my lord, serial number 12.
It is by pen.
Correction fluid, my lord.
It is there.
Serial number 12, my lord. Yes.
You have a look.
I have.
You have a look. It is in the first, at least in the third, that is seal number 12.
Yes, my lord.
Crowbar jumper. Yes, use of correct 11 has been overwritten by use of white fluid.
Yes, my lord.
But my instruction goes that he has never.
No, you see with your own eyes. It is not that above it, it is below it. Seal number 12. 11.
11, yes.
You look at the word 11.
Yes, it seems.
Seems. So when it goes to the performance,
But my clear instruction is that he is.
maybe one always declares that he is always right. But that is subject to opinion of others.
So otherwise, Lordship, the matter can be closed on the ground saying that matter has become in praxis.
If you say, then I'll say. Otherwise, I will say that correctly as per terms of the clause 40, page 41.
Otherwise, my client is still disputing that he has not used it. So
Then I will say that then there will be no dispute. There will be no dispute.
Why not?
Yes, there will be no dispute. I will say use of correction fluid shall liable for rejection.
Yes, my lord.
On production of original records, it is seen that
Yes,
there has been use
Yes, my lord.
in the financial bit. End of the matter. If you say infructuous, then I'll declare infructuous.
My lord.
Which one?
may we proceed for matter being infructuous, Lordship?
Infructuous.
Yeah.
Okay then.
My lord.
But whether you'll be answerable.
Yes.
If I declare, you'll not be answerable.
So I'll take care.
Right, Mr. Pangi?
Yeah. I'll take care, Lordship.
Huh?
I'll take care.
Okay, he's taking. Otherwise, I am ready
Yeah, I'll take.
to take the burden upon me.
I'll take care, Lordship.
Okay, heard Mr.
GG, Lordship.
Z. So, conservator petition, and Mr. B. Picha,
Yes,
standing counsel, Rural Development Department.
yes, my lord.
First of Mr.
5 and 6.
Picha
Yes.
has produced the original records containing the financial bid of the petitioner, which was declared by the bid, which was declared non-responsive by the
Board.
bid evaluation committee
Yes.
on the ground that there was use of
Quite.
Correction fluid.
correction fluid. At places, right? At places.
Yes.
So he has submitted that as per clause Roman 3, subclause Roman 3 of clause 16 of the terms and conditions of the tender, comma, use of correction fluid in a bid is liable for rejection. Full stop. At this stage, Mr. So-and-so, Learned Counsel for the petition has submitted that the subject matter of the petition has become infractious. In view of the above submission of the Learned Counsel for the petition being infractious stands closed.
Right.
Right.
Then you can see, then you show it to your client what the court has observed.
Pass over matter item number 4.
You can examine the matter, you can post it. And then
The section I was referring to is section 80.
80.
80 subclause 2. Subclause 2 1.
CPC
Yes, PC.
seeking exemption
Yes. There are section.
because you are.
I have been exempted from service of notice. I have been exempted from service of notice to the government parties. But the same section, it also says that unless the other party appears, no injunction, whether no interim relief, whether it shall be granted. 82 2 1 subclause 2 subclause 1
80
subclause 2, Your Lordship. May I read, Your Lordship?
subclause
2.
Please.
A suit to obtain an urgent or immediate relief against the government, including the government of the state of Jammu and Kashmir, or any public officer in respect of any act purporting to be done by such public officer in his official capacity, may be instituted with the leave of the court without serving any notice as required by subsection 1. So this has been condoned, Your Lordship. But the next part. But the court shall not grant relief in the suit, whether interim or otherwise, except after giving to the government or public officer, as the case may be, a reasonable opportunity of showing cause in respect of the relief paid for in the suit. This is the section which bars me, Your Lordship.
Now your answer to the notice.
Yes.
See, by what kind of what is your grievance?
My grievance, Your Lordship, is that they issued this prohibitive order on 17 April 2026.
Right.
And then they in the same order, they said that any person aggrieved, they may approach before the authority on 20th April. Now, what they have done is that on 20th, I gave my reply. Now, without any hearing and without any opposition, on the same date, on the 20th, even before the expiry of the 20th day, that time given by him itself, he has proceeded to dismantle my fence. And still he is in the process, Your Lordship. Therefore, I'm praying for status quo, Your Lordship. Now, if you look at the page 38, Your Lordship, this is a very important document on my part, Your Lordship. This is the document issued by the Bogong Bangong Kebang. This is the Bogong Bangong is the one of the supreme authority of the customary court of the Adi community, Your Lordship. There also he is the Kebang has also clearly written to the deputy commissioner that the respondent department they are encroaching into the private land.
School of Business.
Had this letter been by any individual person, Your Lordship, then it could have caused some doubt.
No,
But this is authority, Your Lordship.
Engineering for school building hostel. Again, on
And
Yes, Mr. Ratan. He has made a representation, this or prohibitory
Yes.
order
I'll
says that if any person objects to do so, he may appear before the undersigned at so and so. Till that period, the contents of this order will remain in force.
Yes, my lord. I'll come to that first, my lord. Firstly, my lord, on the facts, my lord, in the writ petition at page 6, the area mentioned is 90,000 square meters.
Page 6.
Yes, it's in the schedule, continuation of para 3,
Yes, in synopsis also, 90,000.
90,000. Now, he has annexed the plaint also in his writ petition. The plaint starts at page 18. Here also, he claims 90,000 square meters.
Yes.
Even in the internal para 3, that is at page 21. Here also, he claims for 90,000 square meters. And at page 36, his representation for land possession certificate, here also he claims for 90,000 square meters. Now, it cannot be said that it is 9,000 square meters.
No.
90,000 square meters, my lord, the overall claim. That apart,
90,000.
whether 90,000 square meters is available in that area or not, my lord, that also is...
In the plaint also you have said
yes,
90.
in the plaint also, in his representation also, in this...
90,000 is a huge area.
Yeah, very huge area.
but in villages, Your Lordship, it is quite possible in villages.
This is
in
a town.
villages,
This is in the heart of the town.
in
This is town, I think.
Yes.
now it is town, Your Lordship, but in earlier time it was not a town.
From the building, page 41, it looks like it is town.
Now, sort of,
Yes, my lord. Now, the order impugn is at page 39.
Yes.
It's a prohibitory order under 152 of BNSS.
Yeah.
Now, there is a procedure under the BNSS. This is a conditional order initially, and there, like earlier CRPC 133 proceedings, and then culminates, my lord. It is a conditional order where he has to show cause all proceedings will be done. One 152, then service or notification of order at section 153, then 154, person to whom the order is addressed to obey or to show cause, then 155, penalty for failure to comply with section 154, then 156, procedure where existence of public right is denied, 157, 158, then 159, power of magistrate to furnish written instructions, power of all this.
157 say, if the person against whom an order under section 152 is made appears and shows cause against the order,
Yes.
magistrate shall take evidence in the matter as in a summons case.
Yes.
If the magistrate is satisfied that the order, either as originally made or subject to such modification as he considers necessary, is reasonable and proper, the order shall be made absolute without modification or as the case may be with such modification.
Yes.
If the magistrate is not satisfied, no further proceeding shall be taken in the case.
Yes.
Provided that the proceeding under section shall be completed as soon as possible in a period of 90 days, which may be extended for reasons to be recorded in writing to 120 days. Then he should, magistrate should complete the procedure.
Complete the procedure.
Yes, shows cause.
Yes, my lord. This impugned order was on 17th of April,
Yes.
and the date fix was on 20th of April.
Yes.
Now he has so cause made his objection on 20th itself.
Why don't you take instruction and
Thereafter, what
you
proceedings?
can take instruction.
Yes, my lord. On further, my lord, my submission will be, now these are proceedings under the BNSS, and he has filed this writ in the form of a writ petition. The very maintainability of a writ petition against an order of an executive magistrate, whether this will be maintainable or not.
This should be subject to revision otherwise.
Yes, my lord.
No,
Criminal revision.
Your Lordship, this
Criminal revision under 438
Yes.
BNSS.
my submission, Your Lordship, that the magistrate, he has failed to comply with the procedures. Now he has given the order on 17 April, and the next 2 days, Saturday and Sunday. So very tactfully, he has taken, because the,
But by the 20th, you have submitted.
yes, I have submitted, but no hearing was done, Your Lordship, and no further findings were done. I have annexed some photograph, Your Lordship, where the date is
No, the
written.
question is about the procedure.
Yes.
He is raising the point of maintainability. This, under CFSC, this order is subject to revision.
No, Your Lordship. What I'm submitting
Why?
is that, because this is a title, basically it is a title.
No, don't mix up with title suit now.
It is a claim of ownership, Your Lordship. Basically, this is a claim of ownership.
That will be decided by the civil court.
Yes,
You have already instituted a suit
yes, Your Lordship.
for right, title, on interest and possession.
Yes. So what
Possession.
I'm saying, Your Lordship, that when the matter is subjudiced, now he has no authority to invoke 152. So I'm praying for the matter.
No, because again, you say, see your base, your representation. See your representation. Page
Yes, yes,
40. In the area adjacent to the land of Veterinary Training Institute,
Yes, Your Lordship.
I have my own private land, which is clearly distinct from the land of the IDDPN Veterinary Institute.
Yes, Your Lordship.
That is clear.
Yes.
My land does not fall within their land.
Yes, Your Lordship.
This is also clear.
Yes.
It is totally a separate land.
Yes.
Clear.
Yes.
I am the rightful landowner as my grandfather has neither so and so, so and so. Right?
Yes, Your Lordship.
Next para. I have instituted a title suit. So you know your boundaries. Title suit number 9 of 2026. What is that? See the relief sought for. What is the plaint? For declaration of title, right, and possession in favor of the petitioner. Seeking declaration of title, right, possession over a plot of land measuring 90,000 square meter at Gumin Nagar in favor of the petitioner. Right?
Yes, Your Lordship.
Now let us C, the relief. Declare the right, title, and interest of the suit. Pass preliminary decree. And restrain all the so-and-so defendants. Right. And when it was instituted, 25 to 2026.
Yes, Your Lordship.
So service of notice is definitely complete.
Now,
What is the status? Last date,
Next date is on 28th.
28th of this month.
28/4.
He can approach there,
In my
with
submission, Your
a-
Lordship, is that
injunction petition also.
there also I will still be barred because the notice upon 3 and 4 it is not complete due to postal deficiency.
Huh?
Due to postal service inefficiency, the notice could not.
Oh, your process service in deficiency.
Now, Your Lordship, the main issue here is, can the district magistrate invoke criminal jurisdiction in civil matter? That is the main issue, Your Lordship.
No. This is, see, so far as jurisdiction is concerned, there is no issue. That has the power.
And one more issue, Your Lordship.
It is under section 152.
Yes.
And see subsection 2 of section 152. They are defending their land.
And I'm
That is what they say
yes.
in the order. They are defending their land, the government land. They say any of the person causing such public nuisance shall desist from all types of construction and art cutting inside the allotted area of IDDP. And you say in your representation, my thing is separate.
Yes. Now that has been proved by the
Further, any trespassing on government land through alternate routes is also prohibited. Trespassing inside the government land. And you say that is separate land, my land, private land.
that is the
These are disputed questions of fact.
yes, sir.
How
Yeah.
can we,
Therefore, Your Lordship, let the
from your own environments, page 40, your representation before the Deputy Commissioner, that my land is separate, my land is private, your land is government.
yes, sir.
I have instituted a title suit.
Now,
You are a party to the suit.
Your Lordship, what I'm submitting is that
It is a competent court.
it is my land, but then they are not recognizing.
Where is the bar, 152 bar, to pass an order?
Yes, the first.
This is your exact case.
Yes, Your Lordship.
Where is the bar?
The first thing, Your Lordship. Now, if they say that it is a public land, Your Lordship, what would be the appropriate step in such case, Your Lordship? The appropriate step in such case is that they have to submit notice under Arunachal Pradesh Public Premises Act, Your Lordship, because that is the exact act which deals with the eviction of public premises.
That I know. But you
now-
yourself say my land is separate.
I'm claiming it is my land, but they are encroaching into my land. That is the court issue, Your Lordship. And that has been proved by the order of the Kabang, Your Lordship, where they have also clearly stated.
No, I have seen Mr. Kabang, his statement.
Yes,
From the available oral sources,
yes,
the said area was agricultural land of Tagum Tamin. Available oral sources. That is also
but
shaky.
they have also clearly said that they are encroaching into.
That is also shaky.
But the previous statement, Your Lordship, where it says that they have encroached into the private lands, Your Lordship.
Mr. Roshan, you find out the up-to-date status of this proceeding?
In fact, when the writ petition itself is not maintainable,
It is because they have no.
it is not at all maintainable. Let him withdraw and let him come up. Let him approach the appropriate. Otherwise, all these
Isn't
years,
133, 144, 145, this criminal revision
yes,
before the sessions judge, not district judge.
No,
District and session judge serves dual capacities. It is before the session judge, a criminal revision will lie
now,
against an order.
and my lord will kindly note also, all these years he says that he is in possession, but there is no iota of evidence also, neither in his plaint or even before this honorable court, how he is in possession.
Now,
No description.
the evidence will be provided during the trial of the case, Your Lordship.
How was
That,
he
that
in
cannot
possession?
be, that cannot be raised
Just
as of today.
making a statement that it is in my possession, but how he is in possession, that also has not
The
been described.
prime issue, Your Lordship, here is that.
Neither in this writ petition nor in the plaint itself.
Now, second issue, Your Lordship, that can the claim of titleship over one's land, can it be called as a public nuisance, Your Lordship? That is also a core issue. Now, if such practices allowed, Your Lordship, then instead of reverting to all the other acts like Public Premises Act, they will simply invoking this act and use it to encroach into any other land, Your Lordship.
No, Mr. Counsel,
Ketacha.
the order is
Yes.
152.
Yes.
Trespassing. They have said trespassing. They have said trespassing,
Yes.
not unauthorized occupation. Right. And what they have said,
Therefore,
a small thing matters. I'm looking at your plain, like 1 minute.
In fact, my lord, what is happening? This earlier, long time back, the veterinary department were allotted this around 42 acres of land. Now the entire land was not put into use. Now seeing the vacancies, the people are trying to encroach upon it, my lord. Please.
Or Your Lordship, if
And they were never in possession. They now seeing the vacant land, they are
now,
filing, instituting suit and all these things.
if
ma'am.
that is the case, Your Lordship, then let the committee be formed, Your Lordship.
No, no. What you are thinking? I'll write an institutional affair against you.
No, because Your Lordship, what I'm submitting here, it is
Thing in a suit. You go pursue the suit. I have read your plaint. Everything you have sought for, relief you required has been sought for in the suit. You pursue the suit.
then at least Your Lordship, till the next date of hearing before the competent civil court, Your Lordship, at least let the
And you made the process deficient, making sure that the process is not served upon the defendants.
no, Your Lordship. Therefore, Your Lordship, till the next date
I'll
of
simply issue notice, maintainably keeping open, so that you won't say that it is dismissed in limine. I have not found anything. Maintainably, it is a criminal revision petition which is to be filed to challenge the order, not in a petition.
Your Lordship, my one last submission would be that they need to invoke the proper jurisdiction of law, Your Lordship.
Huh?
They need to invoke the proper jurisdiction of law. Now, my claim is that it is my land. Their claim is
It is disputed, sir.
yes.
On disputed question of fact, court does not exercise any
Yes, Your Lordship.
mandamus.
Yes, Your Lordship. But
That is disputed, clearly disputed from your plaint itself. Two options are available to the petitioner.
yes,
If suppose the government authorities encroaches upon your land, right,
yes, Your Lordship.
by high-handed action. But here is a case, your position itself is disputed. That is why I am trying to find out, that is why I have been asking question, what is the documentary evidence regarding title? Yes, LPC, now I can understand that LPC is privacy document regarding at least possession, occupation, whether title or not, I don't know. But possession and occupation, yes. But you don't have any LPC also.
No, because it is your,
Heard Mr. So Learned Counsel for the petition. And Ratan.
I'll be appearing for 1, 2, 4, and 6. My friend will be appearing for 3 and 5.
Appearing for 3 and 5.
Mr.
K.
Ja-
Dubey, on behalf of his
K.
standing counsel.
Okay. Please write down the name for the respond number. 3 and 6.
3 and
3 and 5.
5. Post up. This petition is referred to a sale and order dated 17/4/2026. Passed by the respond number 4. Properly in exercise of powers under section 152B and SS 2023. Post up. The petitioner, in response to the order dated 17/4/2026, has filed an objection before the respond number 4 on 20/04/2026, seeking recall of the order dated 17/4/2026. Post up. The petitioner has raised an issue of forcible encroachment into the petitioner's plot of land. Post up. In this connection, the petitioner has already instituted a title suit, title suit number 09/2026, wherein notices have been issued to the defendants on 28, where is that order? Where is that order? Trial court order?
yes,
Ah.
and then your chief.
Issued to the defendants on 25/2026 for their appearance on 28/4/2026. Post up. It is if there is in case in respect of any grievance of the petitioner regarding forcible encroachment in the petitioner's plot of land, it is open for the petitioner to raise such contention in title suit number so and so, and to seek injunction against the defendants as per provisions of law, so as to restrain the defendants from any alleged unauthorized encroachment into the petitioner's plot of land. Post up. From the in the objection to the order dated 17/4/2026 in a written objection filed by the petitioner on 24/2026 to the order dated 17/4/2026. The petitioner has mentioned that his plot of land is adjacent to the plot of veterinary training institute. Full stop. His plot of land and his plot of land is distinct, clearly distinct from the land of the IDDP. IDDP means Integrated Dairy Development Project, within bracket IDDP, and Veterinary Institute. First, he has further mentioned that his land does not fall within the land of the IDDP and Veterinary Institute, and it is a separate land, plot of land. Full stop. Para in view of the remedy available before the court, in view of availability of appropriate remedy. Under the law, comma, this writ petition is not entertained. Full stop. Is found on this court is of the considered view that this writ petition is not to be entertained. Full stop. In any of the matter, an order under section 152 Bharatiya Nagarik Surakha Sanhita can be assailed under the provisions of the BNSS by way of preparing a criminal revision petition. In the event of any lack of jurisdiction, lack of power, authority, and jurisdiction on the part of the issuing authority. One more. From the statements and averments made in the writ petition, it clearly emerges that there is a dispute as regards the proper boundary of the petitioner's plot of land and the parcel of land allotted to IDDP and Veterinary Institute. And such disputed questions of land, such disputed questions of fact cannot be determined within the scope and ambit of Article 226 of the Constitution.
Item number 18.
Is it not complied?
Yeah, I have already complied, my lord.
Who is for the petitioner?
I'm
Please see the order first, against which you have filed the contempt petition. What is the order? That page 17, to furnish a copy of the award.
Yes, Lord.
Right?
Yes.
And the Deputy Commissioner shall inform the petitioner about the manner in which the said award was so published. Right?
Yes, Lord.
Now see the affidavit. Who is Rekeningo?
Rekeningo is the counsel for the petitioners.
Right.
Yes. And he himself acknowledged.
Acknowledge everything.
Yes.
And it is published in the Gazette.
Yes, my lord.
You see Gazette publication. And he has thanked him. Your colleague has said that your good office, I thank that extended needful help.
Yes.
Yes, you read your colleague's letter. What, Mr.
B. Sibo.
Sibo, Land Council for the petitioner, Mr.
G. Ingo.
The Land Council for the parties have submitted that the direction made in the order dated 24/7/2024, passed in the writ petition WBC number 208/2024, has since been complied with. Post of. I've gone through the statement and averments made in the affidavit of the sole respondents. Post of. As the order, direction in the order dated so has since been complied with, learned council parties have submitted for closure of the contempt petition. Full stop. It is accordingly closed.
Earlier pledge.
Item number 19.
May I please, madam?
Yes, sir.
Lordship, I'm attached.
AD card awaited. 457. Yes.
Yes, Your
Let us await.
yes.
Heard Mr. Soyenshal and Councillor Petitioner Miss
Ojarang, Your Lordship.
for respond number
Respondent number 1, 2, 3, and 6, Your Lordship.
1, 2, 3, and 6. In view of office note dated 23/4/2026, we wait for the service reports in respect of the respond number 4, 5, and 7. Release the case after 2 weeks and get 2 weeks by the office.
Much obliged.
Item number 20.
My lord, I am appearing in item number 20 on behalf of respondent number 3, my lord. They're not appearing for the last 5 hearings, my lord. Last date of hearing.
Yes, madam. Can we close?
Okay, Lordship.
Dismiss for not prosecution.
Okay.
Any interim order? Vacated.
Vacated, my lord.
There is no representation on behalf of the petitioner today on call. Post stop. Miss
Ojarang, Your Lordship. Appearing on behalf of Jarang.
Jerang, Learned Counsel on behalf of Mr. M. Kato,
Yes, Your Lordship.
Learned Deputy Solicitor General of India for the respondent number 1
One
and 2, and
yes.
Mr. A.K. Pandey.
Abhijit Kumar Pandey, my lord, for respondent number 3.
A.K. Pandey, Learned Counsel for the respondent number 3, within bracket virtual mode, are present. Post stop. The writ petition was listed. When the writ petition, on the 2 previous dates of listing of the writ petition on 17/3/2026 and 22/4/2026, there was no representation on behalf of the petitioner. Full stop. The learned counsel for the respondents were present on those occasions also. Full stop. When the petitioner was found absent on 2 occasions, full stop, in view of non-representation on behalf of the petitioner continuously for 3 occasions, it transpires that the petitioner is no longer, this court is persuaded to take a view that the petitioner is no longer interested to pursue the writ petition. First of all, the writ petition is therefore dismissed for non-prosecution.
Obliged, my lord.
Much obliged.
Item number 21.
Yes, Deepang.
Office note indicates a service upon respondent 3 and 4 are awaited. And my lord, in the meantime, I also take instructions and anything survives. This is connected to item 20, actually, same work.
Item number
20.
Which has just closed.
Yes.
Yes, my lord. They have not supplied the copy to us, my lord. I am a innovative.
Office note, we have taken steps, my lord. Office note.
You are PRA Nurabi Kol.
My lord, I am appearing
Mr. Pandey?
Yes, my lord. Yes, my lord.
Previous one. So you have entered appearance.
Yes, my lord. Previous one was for different issue, my lord, and this one was was filed in October 2025, I suppose, if I am not wrong, my lord.
He can appear for respondent number 3.
Yes.
So survives on
That I will take
Not
instruction.
sufficing.
Why?
Because the previous one was dismissed, my lord, and now there is no such issue left, my lord. Because now mines
But the
belongs
same-
to us.
Same petition or different petitioner?
Different.
Different petitioner.
Yes, my lord.
Different petitioner. What is your cause of action?
My lord, my bid was rejected.
Okay.
I'll take
Children to
instructions.
declaration of the respondent number 3 as a principal.
Yes.
Auction of coal mines, as the petitioner could not upload the price bid due to technical glitches in the portal. That is the one.
Yes. I'll take instructions.
Petal engineering,
Maybe.
Petal engineering, and recently asphalton or something by Honorable Justice Puya. This kind of plea
I will
is not
take-
open.
There's no interim order also in the. I'll take.
This kind of plea will not be open. Non-uploading means finish.
Apparently. In the, but next time, maybe I can withdraw.
Okay. Mr. You enter appearance? You
My
have
lord.
entered appearance for respondent number 3.
I
Okay.
have, my lord.
Okay. You have a local counsel?
I have a local council, my lord.
Who is your local counsel?
Local council.
So that Mr. Panging can serve a copy.
Yes.
My
But
lord,
Mr.
I need to
Panging
check with the client, my lord, who is the local council for this matter, my lord.
Okay, you apprise your local name of the local council
My lord,
to Mr. Panging.
my lord, we will.
Within 3 days? Within
My
3
lord, yes.
days?
Within 3 days, we will.
In his email
Email, my lord.
Yes.
ID.
My
In his email ID, right?
Yes, my lord.
So that he can serve a copy to you within next 3 days. And will await service of notice upon the respondent
Yes,
number 4. Heard Mr. D. Panging, landed counsel for the petitioner. Ms. So-and-so, landed counsel on behalf of Mr. So-and-so, DUI as DUI for the respondent number 1 and 2. Post of Mr. R.K. A.K. Pandey, learned counsel for the respondent number 3, has appeared virtually and has submitted that he has instruction to enter appearance on behalf of the respondent number 3. First off, he has, first off, as per office note, office note dated 23/04/2026 has reported that neither ID card nor answer notice has been received back from the respondent number 3 and the respondent number 4. First off, in view of appearance of Mr. Pandey, learned counsel for the petition, learned counsel for the respondent number 3, the notice can be served upon the learned notice for the purpose of service upon the respondent number 3 can be served upon the engaged learned counsel. So Mr. Pandey has submitted that he'll intimate the name of the local counsel for the respondent number 3 to the learned counsel for the petitioner via email within 3 working days from today. First off, on being so intimated, the learned counsel for the petitioner shall have a copy of the writ petition along with the annexes to the said learned counsel within next 1 week from the date of intimation. Await for the service report in respect of the respondent number 4. Release the case after 2 weeks on a date 2 weeks.
Much obliged.
Obliged, my lord. Much obliged.
Meeting tonight?
Item,
Yes, councils are available now. We continue.
yes. Item number 23.
It has come for what?
Yes, Your Lordship.
Hmm.
So, Your Lordship, this writ petition
raises a very narrow but significant issue, whether an executive authority can be refused to implement the order, final and binding order, despite there being no stay, no challenge, and no pending proceedings, Your Lordship. The executive magistrate order dated on 25/8/2020.
Who are the petitioners?
Hemi Clan, Your Lordship.
Order has been passed by executive magistrate. Okay, we put it in an admission column on an agreed date. On an agreed date, not in the orders column.
No, Your Lordship.
Get to an agreed
exclude-
date, agree to an agreed date.
Fixed date, Your Lordship.
Yes, agree
Yes.
to an agreed date.
Yes, sir. Okay, Your Lordship.
He says 2 weeks, so within 2 weeks or immediately after 2 weeks. Agree,
2 weeks.
Miss so-and-so, please give the names. List the case on so-and-so in the admission column. An endeavor will be made to give consideration to the writ petition.
So, Your Lordship, 28th of this month, 20th of
No,
period,
after 2 weeks.
2 weeks. So,
We have
any
posted
specific
many
date?
matter. Yes, please.
11 May.
Five or six? Six.
Six.
Yes, Your Lordship.
6,
Six.
agreed.
Obliged.
Okay, 6.
Highly obliged.
In the admission column, huh?
Item number 24.
May it be your lordship.
Yes, yes.
I could not travel this time for some cases here, madam. And this matter.
Yes, for what?
actually, madam, although it has come up for orders, actually parties have exchanged, government has filed their affidavit. Can it be taken up on Monday, my lord? Because there is some urgency in the matter. This relates to payment of compensation to the project affected members of a.
We have posted
Rangana
many
Diya.
matters already. We have posted many matters by way of adjournment in the next week.
My lord,
Next
my lord,
week.
problem is, my lord, if the fund is released, then we'll be deprived of our share, which we are entitled under their own policy guidelines, my lord. This is the case, my lord. The MLA interfered and he changed the policy, although he was only in a committee to
Yes,
implement the policy.
All are served.
Yes, well, we have
Okay.
filed our affidavits.
Because
Can it be taken up on
by way
Monday?
of adjournment, many cases have been fixed now.
Yes.
From this week to next week. So
Well,
not
let us
possible.
make
And
an attempt on Monday, because I would like to argue it by appearing physically, my lord. Monday I'll be going there so that.
No, many
you
matters
kindly-
for disposal, many matters
this
for
is a-
disposal have been.
But this is a very short matter. Issue is very simple. No adjudication is necessary. Their own policy guidelines.
Yes, Mr.
Yes, the policy guidelines, what my learned senior is harping on,
Only-
is not applicable. It's not applicable.
That is the only issue, my lord. Your lordship can decide, my lord. Let it be on Monday, my lord.
List the case on Monday. But I don't give you guarantee.
My lord, let
I
it come up
don't
for
give you-
admission. My lord, all
I
right, my lord,
don't give you don't give you guarantee.
my lord, I'll appear physically. I'll
Your
try to persuade your
your
lordship.
travel may be useless.
My lord, it will be my
No, why
pleasure
so
to appear
urgency?
before your
What
lordship.
Is there anything?
Yes, my lord. Fund will be released and will be deprived of our share. Once the fund is released, my lord, it will be difficult to get back the fund. Private persons will
Right.
be distributed.
If it is 4th of May, will there be any problem?
4th of May. 4th
Because
of May,
Mr.
my
Ratna,
lord.
we have already posted many matters for.
Yes,
My lord, let me make an attempt on Monday. If it is very short, your lordship will dispose of. Otherwise, your lordship will adjourn the matter.
Okay.
My lord. Let it come up in the admission column, my lord.
You'll come to know why I have said so. Okay.
Item number 25.
Obliged.
Here, the respondents have not filed the affidavit and the office.
Service
also
report awaited.
Yes.
Who is respondent number 5?
Yes.
You have entered?
Yeah, I'm representing.
Respondent number 5?
Yes, the sole private respondent.
No. Is this the manner in which it is given? No.
No.
File it before the registry.
Man.
Yes, Mr. So-and-so, land counsel for the petitioner. Mr. Ratan, you appear for 1 to 4. Public Works Department, Miss So-and-so. This is State Public Works, PWD.
PWD, man.
Okay, Miss So-and-so, land counsel for the respondent number 1 to 4. Are present, Mr. Tai Kumar. Land counsel has submitted that he has entered appearance on behalf of the respondent number 5, and the wakalat number will be filed during the course of the day. Full stop. As all the respondents are represented, comma, list the case after 3 weeks in the admission column. Their counter affidavits are filed on or before the next date of listing.
My lord, just one prayer, my lord.
Any
Here-
interim order?
Well, interim is there, my
Continue.
lord. Yes, my lord. Interim is there, my lord. It's not till the returnable date. So. it
Okay, the
not
interim
dated.
order passed earlier shall continue till the next date of listing.
No, my lord, it was not, there's no need to extend as such the interim.
Okay, then okay.
Yes, just, my lord, my prayer, my lord, here in the coast list, my lord, the standing council of RWD has been wrongly reflected, my lord.
Okay.
That may be
The name of learned standing council, PWD.
RWD.
Huh?
RWD, my lord. Because inadvertently, in the motion stage, instead of PWD, I had said, I written RWD. So his name has been reflected.
Now, what is to be reflected now?
Now, my lord, this needs to be struck off, my lord. That G. Tarak, RWD, standing council RWD, it needs to be struck off, my lord.
Who will appear? PWD?
Government, yes, government.
Government pleader. Okay. The Mr. So-and-so land counsel for the petition has submitted that inadvertently, comma, he has implemented the the standing council RWD, and the same is reflected in the cause list, which is to be deleted. First of, as the name of standing council RWD, the name of the standing council Jimmy Tarak.
Yes, Jimmy Tarak. Yes.
Sorry, accordingly, the office to delete the name of Mr. Jimmy Tarak, learned standing council RWD, from the respondent side in the call list.